Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. The laws surrounding family law and divorce vary significantly by state and jurisdiction, and the information presented here may not apply to your specific situation. Viewing this video does not create an attorney-client relationship. You should not act or refrain from acting based on any information provided in this overview without first seeking professional counsel from a licensed attorney in your specific area. We strongly encourage all viewers to conduct their own due diligence and consult with qualified professionals before making any legal or financial decisions. Behind the closed doors of wood-paneled offices and sterile courthouse hallways, a massive and often misunderstood machine is operating every single day in the United States. This is an industry where high-stakes emotions meet cold, hard legal calculations. While most people view divorce as a personal tragedy or a private family matter, for those within the legal system, it is a sophisticated, multi-billion-dollar economic engine. Every 13 seconds, another divorce is filed in America, fueling a sector that handles more than 750,000 cases per year. This isn't just about ending a marriage. It is about the systematic redistribution of billions of dollars in assets, the determination of childhood futures, and the navigation of a complex web of state-specific statutes that can make or break a person's financial stability for decades. Welcome to the first part of our deep dive masterclass into the United States divorce lawyer industry. Today we are pulling back the curtain on how this industry actually functions, moving past the Hollywood stereotypes of aggressive courtroom battles to look at the historical trends, the economic incentives, and the structural reality of family law in 2026. If you have ever wondered why some divorces cost $5,000 while others cost $500,000, or why the legal process seems designed to be as long and complicated as possible, you are in the right place. We are going to solve the problem of information asymmetry, giving you the educational framework to understand the mechanics of the legal system, the different tiers of representation available, and how the billable hour model dictates the pace of progress in the American court system. To understand where the industry stands today, we must first look at the massive historical shift that turned divorce from a rare, moralistic battle into a standardized legal product. Prior to 1969, getting a divorce in most U.S. states was an arduous task that required proof of fault. You couldn't just leave a marriage because you were unhappy. You had to prove adultery, cruelty, or abandonment in a court of law. This created a specific type of legal industry focused on private investigators and dramatic gotcha evidence. However, when California passed the first no-fault divorce law under then-Governor Ronald Reagan, it triggered a domino effect that reached every state in the Union. This shift fundamentally changed the business model of divorce law. It removed the need to prove a crime, but it increased the complexity of asset division. Lawyers stopped being moral arbiters and started becoming forensic financial navigators. Historical trends show us that as the legal barriers to entry for divorce dropped, the volume of cases skyrocketed, leading to the professionalization and specialization we see today. In the modern era, the divorce lawyer industry is segmented into several distinct tiers. At the top, you have the high net worth boutiques. These firms handle cases involving celebrity status, complex corporate structures, and international assets. A case study of a high-asset divorce often involves not just one lawyer, but a team including forensic accountants, valuation experts, and tax strategists. In these scenarios, the legal fees can easily reach 6 or 7 figures because the stakes involve the valuation of private equity, intellectual property, and real estate portfolios. In the middle tier, you find the standard practice firms. These are the practitioners who handle the majority of American divorces. They deal with the division of the marital home, 401k accounts, and the establishment of child support and alimony. Here, the industry relies heavily on the retainer model. When a client hires a lawyer, they are typically required to pay a significant sum up front, often ranging from $3,500 to $15,000, which is placed into a trust account. As the lawyer works, they draw from this account at an hourly rate. This is where many consumers feel the most friction, as the billable hour can include everything from a 5-minute phone call to a 30-minute email exchange. Historical data suggests that the average contested divorce in the United States costs approximately $15,000 to $20,000 per person, largely driven by the time spent in the discovery phase. The discovery phase is the engine room of the divorce industry. This is the formal process of exchanging information, and it is where the most significant legal work occurs. It involves interrogatories, which are written questions that must be answered under oath, and requests for production, which demand every bank statement, tax return, and credit card bill from the duration of the marriage. In a masterclass overview of this industry, it is crucial to understand that the lawyer's role is to ensure that the marital estate is fully identified and valued. If one party hides an offshore account or a cryptocurrency wallet, the lawyer's job is to use legal tools, like subpoenas, to bring that information to light. This process is exhaustive and by design expensive, because a single missing document could result in a client losing out on thousands of dollars in a final settlement. Beyond the individual lawyers, there is a massive ecosystem of supporting professionals. This is what many experts call the divorce industrial complex. In 2026, a standard litigated case might involve a vocational expert to determine a spouse's earning capacity, a guardian ad litem to represent the best interests of the children, and a QDRO, qualified domestic relations order, specialist who does nothing but handle the technical transfer of retirement funds. Each of these professionals adds a layer of expertise, but also a layer of cost. The industry has evolved this way because the legal standards for equitable distribution, or community property, have become so technically demanding that a general practice lawyer can no longer manage them alone without risking malpractice. We also have to look at the rise of alternative dispute resolution, or ADR. This is a burgeoning sector within the industry that includes mediation and collaborative law. Potential outcomes in these tracks often involve lower costs and faster resolutions because they bypass the traditional courtroom setting. In a mediation model, a neutral third party helps both spouses reach an agreement without a judge's intervention. However, even in mediation, lawyers are often present to act as consulting counsel. This represents a shift in the industry's focus from litigation, fighting in court, to negotiation, reaching a settlement. Case studies show that roughly 90% to 95% of all divorce cases in the U.S. settle before reaching a final trial. This means the vast majority of a divorce lawyer's work happens in a conference room, not a courtroom. As we move forward in this series, we will examine the specific mechanics of child custody, the math behind alimony, and how technology is disrupting this traditionally slow-moving industry. Understanding the divorce lawyer industry requires looking at it not just as a legal process, but as a business system designed to manage risk, value assets, and provide a structured exit from a legal contract. By the end of this overview, you will understand the levers that move the system, the reasons behind the high costs, and the historical trends that continue to shape how families are restructured in the eyes of the law. This is the foundation of the deep dive. Recognizing that in family law, information is the most valuable currency, and the lawyer is the professional tasked with securing it. To understand how that information is secured, we must look at the financial architecture of the attorney-client relationship. When you walk into a family law firm in 2026, you are not just buying a result, you are purchasing specialized units of time. The most common entry point into this industry is the retainer agreement. Think of the retainer not as a flat fee for the entire divorce, but as a security deposit held in a specific type of bank account called an IOLTA, or interest on lawyer trust account. In the United States, these accounts are strictly regulated. The money remains yours until the lawyer earns it by performing work. However, the industry has evolved a mechanism known as the evergreen retainer. Imagine a client named Michael in 2026. He signs a contract with a mid-sized firm in Chicago. He provides an initial retainer of $7,500. The evergreen clause in his contract states that if his trust account balance drops below $2,500, he must immediately replenish it back to the original $7,500. This ensures the law firm never works for free and always has a cash buffer to cover upcoming litigation costs. From a business perspective, this creates a consistent cash flow for the firm, but for Michael, it can lead to a phenomenon known as the replenishment shock, where he is hit with a bill for $5,000 just as the case is heating up. Historical trends show that as litigation becomes more aggressive, these replenishments happen more frequently, often catching clients off guard. The core unit of currency in this industry is the billable hour, typically broken down into 6-minute increments, or 0.1 of an hour. If a lawyer spends 3 minutes reading an email from Michael, that is billed as 0.1. If they spend 7 minutes, it becomes 0.2. This granular tracking is why the divorce industry is often criticized for its lack of price transparency. In 2026, The average hourly rate for a junior associate in a major U.S. city ranges from $300 to $450, while senior partners can command $700 to $1,200 per hour. Let us look at a case study involving a dispute over a single asset. Imagine a couple, Sarah and Mark, who are fighting over the equity in their primary residence. Sarah's lawyer sends a settlement proposal. Mark's lawyer receives it, reviews it for 0.5 hours, calls Mark to discuss it for 0.4 hours, and then drafts a counterproposal for 1.2 hours. Between the two firms, that single exchange has generated over 2 hours of billable time. At an average rate of $400 per hour, the couple has spent $800 just to say no to the first offer. When you multiply this by hundreds of emails, dozens of phone calls, and multiple court appearances, you begin to see why the average contested divorce costs so much. In 2026, the industry is seeing a massive shift toward technological integration to handle the heavy lifting of discovery. Discovery is the formal exchange of information where both parties must disclose every financial detail of their lives. In the past, this meant paralegals spent weeks manually reviewing paper bank statements. Today, the industry utilizes AI-driven forensic tools. These programs can ingest 5 years of digital bank records and credit card statements in seconds, automatically flagging transactions that look like wasteful dissipation of marital assets. For example, if a spouse has been secretly spending money on a high-end hobby or an undisclosed relationship, the software will highlight these anomalies. While this technology potentially reduces the hours spent on manual review, the industry has adapted by shifting those billable hours toward the expert analysis of the data provided by the AI. Step by step, the staffing of a divorce case follows a specific hierarchy designed to maximize firm revenue while theoretically providing the appropriate level of expertise. At the bottom is the paralegal, who handles the administrative filing of motions and the organization of the digital case file. Their time is billed at a lower rate, perhaps $150 to $200 per hour. Above them is the associate, who does the bulk of the legal research and drafting of documents like the statement of net worth. This document is the most important piece of paper in a U.S. divorce. It is a comprehensive sworn statement of everything you own and everything you owe. Finally, the partner oversees the strategy and handles the high-stakes negotiations or courtroom trials. A common industry practice is the multi-lawyer conference, where both a partner and an associate attend a meeting or a hearing. This means the client is being billed for both professionals simultaneously, which can lead to a rate of over $1,000 per hour for a single meeting. Potential outcomes in these financial structures vary based on the level of conflict. The industry operates on a conflict-dependent revenue model. If both parties are cooperative, the lawyers act primarily as scriveners, documenting the agreement. However, if there is high conflict, the legal machine moves into high gear. Take, for example, the process of a deposition. This is where one spouse, under oath, is questioned by the other spouse's lawyer in a conference room. In 2026, a single day of depositions can cost upwards of $5,000 when you factor in the lawyer's time, the court reporter's fees, and the cost of the transcript. From an educational standpoint, it is vital to recognize that the legal system is designed to be thorough, and thoroughness in law is synonymous with time. Imagine if a divorce was treated like a fixed-price construction project. While some firms are experimenting with flat-fee models for uncontested cases, the vast majority of the industry resists this because of the unpredictable nature of human emotion. A lawyer cannot predict if a client will call them 10 times a day in a panic, or if the opposing party will refuse to sign a simple document out of spite. Therefore, the billable hour remains the protective shield for the firm's profitability. Furthermore, we must address the hidden costs often referred to as disbursements. These are out-of-pocket expenses the firm pays on your behalf and then bills back to you. In 2026, this includes filing fees for the summons and complaint, which can be several $100s depending on the county. It also includes the cost of process servers who physically deliver the papers to the spouse, and the fees for specialized software used for child support calculations. In high net worth cases, these disbursements can also include the retainers for outside experts. If you need to value a private business, you might need a business valuation expert who requires their own $5,000 retainer. If you are disputing the value of a pension, you need an actuary. The divorce lawyer acts as the general contractor, hiring these subcontractors to build the evidentiary case. This brings us to a critical realization about the industry. The lawyer is not just your advocate. They are the manager of a very expensive professional network. Every person they bring into the case, from the forensic accountant to the vocational expert who evaluates a spouse's future earning potential, is another gear in the machine. Each gear requires financial lubrication to turn. This structural reality is why historical trends indicate that many middle-class families see a significant portion of their marital equity consumed by the process of dividing it. The industry is built on the premise that a precise, legally sound ending is more important than a cheap one. But what happens when the money runs out before the case is over? What happens when one spouse has all the access to the funds and the other has none? This creates a massive power imbalance that the legal industry has developed specific, yet complex, tools to address. We are seeing a rise in litigation 2026 where the moneyed spouse is ordered by the court to pay the legal fees of the non-moneyed spouse, just to keep the playing field level. But getting to that order is a legal battle in itself. In the next part, we are going to dive into the specific math behind the two most contentious pillars of the industry: child support and alimony. We will look at how the 2026 tax codes have changed the way these payments are structured, and why the formulas used by the courts might not be as objective as they seem. We will also explore the psychological warfare of the initial filing, how the way a case starts often dictates how much it will eventually cost. Why is the first-to-file advantage such a heavily debated topic among professionals? And how does the location of your filing, your specific county, change the rules of the game entirely? The answers lie in the intersection of geography and strategy. The strategy of a high-stakes divorce begins the moment a summons is served, but the real work often happens weeks before that. In the United States legal industry, the concept of forum shopping is a sophisticated reality that dictates the financial trajectory of a case. Imagine a couple, Robert and Elena, who own properties in both Texas and California in 2026. Texas is a community property state with strict caps on alimony, making it traditionally more favorable for the higher earner who wants to protect their future income. California is also a community property state, but has much more flexible and potentially generous spousal support laws that could last for half the length of the marriage. If Robert files in Texas before Elena files in California, he may successfully lock the case into a jurisdiction that protects more of his post-divorce wealth. This is why the first-to-file status is not about winning a race for the sake of speed. It is about choosing the legal landscape and the specific set of statutes that will govern your life for the next decade. When we look at the county level, the differences become even more granular. In 2026, some suburban counties in the U.S. may have a backlog of cases lasting 3 years due to budget constraints or high volume, while a neighboring rural county might process a decree in 6 months. Experienced lawyers often analyze the recent rulings of specific judges to determine where to seek a venue. If a particular judge has a historical trend of awarding high temporary maintenance, or has a reputation for being strictly formulaic with child custody, a lawyer will use every legal maneuver possible to either keep the case in that courtroom or move it to a different one. This process involves filing motions for a change of venue or arguing that a specific court lacks jurisdiction, adding thousands of dollars in billable hours before the actual divorce issues are even mentioned. Now, let us step into the heavy-hitting math of child support. In the United States, child support is not a suggestion or a negotiation. It is a federal mandate that requires states to have clear, math-based guidelines. In 2026, most states utilize the income shares model. This model is based on the philosophical idea that the child should receive the same proportion of parental income that they would have received if the parents were still living together. Imagine if the combined monthly net income of the parents is $15,000. The state provides a specific grid that says at that income level for 2 children, the total cost of raising them is exactly $3,800 per month. If the father earns 60% of the income and the mother earns 40%, the father is responsible for 60% of that amount. However, the deep dive into this industry reveals the hidden complexity of add-ons. The base support amount only covers the basics like food, clothing, and shelter. In the 2026 economic reality, the cost of health insurance premiums, high-tier educational tutoring, and competitive club sports can easily eclipse the base support amount. Lawyers spend dozens of hours arguing over whether a $6,000 summer camp or a private violin tutor is a reasonable and necessary expense or a luxury that should be excluded. Step by step, the lawyer must document these expenses, often requiring a lifestyle analysis. This is where a financial expert is hired to compare the spending habits during the marriage to the proposed post-divorce budget, ensuring that the child's standard of living remains as close to the marital standard as possible. Then we hit the most volatile part of the industry: alimony. also known as spousal maintenance. Unlike child support, which is mostly a calculator exercise, alimony is where the lawyer's skill in narrative building and historical trend analysis truly shines. There is no federal chart for alimony. Instead, judges look at a list of statutory factors. These include the length of the marriage, the age and health of the parties, and the need of the recipient versus the ability to pay of the provider. Consider a case study of a stay-at-home parent in 2026 who has been out of the workforce for 12 years. Their lawyer must argue for rehabilitative alimony. This is not intended to last forever. It is designed to provide a financial bridge while the spouse goes back to school or gains new job skills. The lawyer will hire a vocational expert to testify about the current job market and how long it will take for that spouse to become self-sufficient. On the other side, the higher-earning spouse's lawyer will use case studies to argue that the recipient is underemployed and should have their income imputed. This means the court treats them as if they are earning a certain amount of money, even if they currently are not, thereby reducing the alimony award. The process of imputing income is a fascinating step-by-step chess match. A professional evaluator will sit down with the spouse, review their resume, their education, and the labor market. They might produce a report stating that while the spouse is currently earning $0, they have the capacity to earn $90,000 as a marketing manager. The lawyer then takes this report to the judge. If the judge accepts it, the math for both child support and alimony is calculated as if that $90,000 is actually hitting the bank account every month. This creates a massive financial squeeze, designed to prevent one party from artificially depressing their income to gain a litigation advantage. The tax landscape of 2026 adds a final layer of complexity to these financial battles. Following the historical trend set by the Tax Cuts and Jobs Act, alimony is no longer tax-deductible for the person paying it, and it is not considered taxable income for the person receiving it. This was a massive shift that completely changed how lawyers negotiate. Before this change, the government essentially subsidized divorces by allowing the higher-earning spouse to pay in pre-tax dollars. Now, every dollar of alimony costs the payer significantly more. Lawyers in 2026 have responded by focusing on the net effect of every deal. They now look toward front-loading settlements, where the payer gives a larger share of the house equity or a larger portion of a 401k upfront in exchange for a total waiver of monthly alimony. This has turned divorce lawyers into amateur tax strategists, often working side by side with accountants to run multiple simulations of how a settlement will look after the 2026 tax brackets are applied. Every single one of these financial determinations is often first addressed in what is called a pendant light hearing. This is a Latin term meaning pending the litigation. It is a mini-trial that happens at the very beginning of the case, usually within the first 60 to 90 days. Because a full, contested divorce in the United States can take 2 years to reach a final trial, the court must decide immediately who stays in the house, who pays the car notes, and how much support is paid in the interim. The outcome of this hearing is statistically one of the most important moments in the entire case. Historical trends show that whatever the judge decides in the temporary order often becomes the status quo that is incredibly difficult to change in the final decree. If a lawyer secures a high temporary support order, they have gained massive leverage for the eventual settlement, as the other side may become financially exhausted and more willing to compromise. But as much as the money matters, there is one area of the divorce lawyer industry that is even more high stakes, more emotional, and more prone to extreme litigation costs. It is the area where the billable hour meets the best interests of the child. In the next part, we are going into the world of custody battles. We will look at the rise of 50-50 parenting as the new legal default across the United States, and how parenting coordinators and forensic psychologists are becoming the most powerful and expensive players in the room. Why are some lawyers now advising clients to keep detailed behavioral logs of every interaction? And how does the 2026 digital footprint, from smart doorbell footage to shared calendar metadata, become the star witness in a custody trial? The shift from physical custody to data-driven custody is changing the industry forever. The transition from physical custody to data-driven custody is a fundamental pivot in the 2026 legal landscape. In the traditional era, custody disputes were often a game of he said, she said, where judges had to make life-altering decisions based on filtered testimony and anecdotal evidence. Today, the divorce lawyer industry has integrated with the digital world to create a process where every minute of a parent's life can be scrutinized. We are seeing a massive historical trend across the United States where the term visitation is being systematically erased from the legal lexicon, replaced by the more equitable term parenting time. This change is not merely cosmetic. It reflects a legislative shift toward the presumption of 50-50 shared parenting. As of 2026, over half of the states in the U.S. have either enacted or are considering statutes that establish a rebuttable presumption that equal parenting time is in the best interest of the child. For the legal industry, this has shifted the burden of proof. It is no longer the job of a father to prove why he should see his children. It is now often the burden of the accusing parent to prove why the other is unfit. This has created a high-stakes environment where lawyers must build an evidentiary mountain to deviate from that 50-50 baseline. Imagine a case study involving a couple named David and Jennifer in 2026. David is a software engineer who frequently travels for work, while Jennifer has been the primary caregiver for their two school-aged children. Jennifer's lawyer might argue that the historical trend of caregiving should dictate the future schedule, meaning David should only have every other weekend. However, David's lawyer will counter with data. They will produce logs from a smart home security system, showing that David was present for 90% of bedtimes over the last year. They will present metadata from a shared family calendar app, proving David attended every pediatrician appointment and soccer practice. In this 2026 reality, the lawyer who has the best data often wins the negotiation before a judge even takes the bench. When a case cannot be settled through data alone, the industry brings in the heavy hitters: forensic psychologists and custody evaluators. This is one of the most expensive and invasive aspects of the entire divorce industry. A full custody evaluation, often referred to in states like California as a 730 evaluation, is a comprehensive investigation into the mental health and parenting capabilities of both parties. The step-by-step process of a 2026 custody evaluation is exhaustive. First, the court or the parties select an expert, typically a PhD-level psychologist. This expert requires a massive upfront retainer, often ranging from $15,000 to $30,000, which the parties must split. The evaluation begins with clinical interviews. The psychologist spends hours with each parent, probing their personal history, their childhood, and their parenting philosophy. Next comes psychological testing. One of the most common tools used in the U.S. divorce industry is the MMPI-3, or the Minnesota Multiphasic Personality Inventory. This test consists of hundreds of true or false questions designed to detect personality disorders, defensiveness, or tendencies toward alienation. Following the tests, the evaluator conducts home visits, observing each parent interacting with the children in their natural environment. They also interview collateral witnesses, such as teachers, therapists, and even neighbors. The final product of this months-long process is a detailed written report. This document often exceeds 50 pages and concludes with a specific recommendation for a parenting schedule and legal custody. Legal custody, which is distinct from physical custody, refers to the right to make major decisions regarding the child's education, healthcare, and religious upbringing. In 2026, the industry standard is joint legal custody, which requires parents to consult and agree on these issues. However, if there is a history of high conflict, a lawyer might advocate for tie-breaking authority for one parent in specific areas, such as medical decisions. This report is so influential that historical trends suggest judges follow the evaluator's recommendation in approximately 80 to 90% of cases. To manage the fallout of these evaluations and the daily friction of shared parenting, the industry has birthed a new professional role: the parenting coordinator. Think of a parenting coordinator as a quasi-judicial referee. They are often attorneys or mental health professionals with the power to make binding decisions on minor disputes without the parties having to go back to court. Imagine if David and Jennifer cannot agree on which extracurricular activity their son should join in 2026. Instead of paying two lawyers $400 an hour to file a motion, they present the issue to their parenting coordinator. The coordinator reviews the situation and makes a final call. While this saves on long-term litigation costs, the parenting coordinator themselves often charges an hourly rate similar to a lawyer, and they are usually kept on retainer for years. We also have to discuss the rise of co-parenting technology as a tool for legal accountability. Apps like Our Family Wizard or Talking Parents have become standard requirements in court orders across the United States. These platforms are designed to create an unalterable record of all communication. In 2026, a lawyer can subpoena the entire communication history from these apps with a single click. Every late response, every aggressive tone, and every missed pickup is time-stamped and geolocated. If Jennifer claims David was late for a transition, David can point to the GPS check-in feature of the app to prove he was at the designated location 5 minutes early. This level of digital surveillance has turned the modern divorce lawyer into a digital forensic analyst. Potential outcomes in custody cases are also heavily influenced by the concept of parental alienation. While it remains a controversial topic in some circles, in 2026 litigation, it is a frequent point of contention. Lawyers are increasingly hiring experts to testify that one parent is systematically undermining the child's relationship with the other parent. This can lead to drastic legal remedies, including a court-ordered change in primary custody or mandated reunification therapy. The cost of such therapy is astronomical, often requiring a specialized team of therapists to work with the entire family over several months, with legal fees continuing to mount as the lawyers monitor the progress. Beyond the physical and legal custody, there is the issue of the right of first refusal. This is a common clause in 2026 parenting plans that states if one parent is unable to watch the children for a certain period, say 4 hours, they must offer the other parent the opportunity to take the children before calling a babysitter. While this sounds like a great way to maximize parental time, it often becomes a source of endless conflict and litigation. Lawyers spend hours drafting the specific parameters of this clause, debating whether it should be triggered by work obligations or social events, and how much notice must be given. This deep dive into the custody machine reveals that the industry is moving away from the idea of a winner and a loser. Instead, it is moving toward a model of managed conflict. The lawyers are no longer just fighting for time. They are managing a complex system of psychological evaluations, digital tracking, and third-party oversight. But as complicated as the custody battles are, they are often overshadowed by the sheer complexity of the financial division when a spouse has been hiding money for years. In the next part, we are going to look at the dark side of the industry, forensic accounting and the hunt for hidden assets. How do lawyers in 2026 find cryptocurrency that was never disclosed? What happens when a business owner artificially deflates their profits to avoid paying a fair settlement? And why is the discovery of a single offshore account or a secret real estate holding the ultimate game changer in a divorce trial? We are going to break down the step-by-step process of the financial audit that can turn a standard divorce into a criminal-level investigation. The search for the truth in a 2026 divorce begins with the lifestyle analysis. This is the industry's primary tool for determining whether the numbers presented on a tax return or a sworn financial affidavit actually match the reality of a person's daily existence. Forensic accountants in the United States do not just look at what you earned, they look at what you spent. Imagine a scenario involving a couple named Gregory and Sophia. Gregory is a consultant who reports a net income of $120,000 a year. However, a deep dive into the last 3 years of their joint and individual bank statements reveals a lifestyle that costs $300,000 a year, including international travel, high-end vehicle leases, and private school tuitions. The forensic accountant's first step is to perform a cash flow analysis. They meticulously categorize every single automated clearinghouse transfer, Zelle payment, and Venmo transaction. In 2026, the digital trail is far more extensive than it was a decade ago. If Gregory is claiming a lower income to reduce his potential alimony obligation, the accountant will look for the source of the missing $180,000. Is it coming from undisclosed dividends? Is it a gift from a family member that should be characterized as income? Or is it coming from a secret business account? This process is often called the smell test because if the expenses don't pass the sniff test relative to the reported income, the court may infer that there is hidden or imputed income available for support. Once the lifestyle analysis flags a discrepancy, the legal industry shifts into a phase of aggressive discovery. Lawyers will issue subpoenas not just to major banks like Chase or Bank of America, but to fintech platforms and even retail giants. In 2026, a subpoena to Amazon can reveal a history of purchases delivered to an address the other spouse didn't know existed. A subpoena to a credit card processor can show that a business owner has been running personal groceries and family vacations as legitimate business expenses. This is known as recharacterization of expenses. Step by step, the lawyer and accountant work together to add these personal expenses back into the business's profit margin. If a business owner claimed $50,000 in travel expenses that were actually for personal use, the lawyer will argue that the business's true profit is $50,000 higher than reported, which significantly increases the business's valuation and the owner's income for support calculations. The most complex frontier in the 2026 divorce industry is the identification and valuation of cryptocurrency and decentralized assets. Gone are the days when a spouse could simply hide a paper wallet in a safe deposit box. Today, forensic accountants use sophisticated blockchain analytics to trace the movement of funds from a known marital bank account into a crypto exchange like Coinbase or Kraken. From there, they track the tokens as they move into private, non-custodial wallets. Imagine if Gregory purchased $50,000 worth of Ethereum in 2022 and never told Sophia. The forensic accountant will look for the initial outgoing wire transfer. Even if Gregory uses a mixer or a tumbler to obfuscate the path of the transaction, historical trends in digital forensics show that most users eventually leave a digital cent. This might be an email confirmation of a trade, a login from a recognized IP address, or the presence of a hardware wallet like a ledger in the home. In 2026, many family law courts have the authority to order a spouse to provide their private keys or face immediate contempt of court, which can include incarceration until the asset is disclosed. The valuation of these assets is also a moving target due to market volatility. Lawyers must often negotiate for a specific date of valuation, such as the date of filing or the date of trial, which can result in a difference of millions of dollars in the final settlement. Business valuation adds another layer of professionalized scrutiny. In the United States, most small to mid-sized businesses are valued using the income approach or the market approach. If a spouse owns a medical practice or a law firm, the industry looks at the goodwill of the business. Personal goodwill, which is based on the specific reputation of the owner, is often not considered a marital asset in many states. However, enterprise goodwill, which belongs to the business itself, is. Lawyers spend countless billable hours debating the percentage of the business that is personal versus enterprise. In a 2026 case study, a lawyer representing the non-owner spouse might hire an expert to argue that the business has high enterprise value because it has a recognizable brand and a large staff that functions without the owner. Conversely, the owner's lawyer will argue that the business would collapse without that specific individual, making the value personal and therefore non-divisible. This is a high-stakes chess match where the expert's reports can be hundreds of pages long, detailing market multiples, capitalization rates, and discounts for lack of marketability. What happens when the forensic audit proves that a spouse has been intentionally dishonest? The potential outcomes are severe. In the United States, a sworn financial affidavit is signed under penalty of perjury. If the court finds that a party has engaged in a pattern of hiding assets or wasting marital funds, a concept known as dissipation of assets, the judge has the power to award a disproportionate share of the remaining assets to the innocent spouse. For example, if Sophia can prove that Gregory spent $50,000 on a secret apartment for a girlfriend, the judge may credit that $50,000 back to Sophia's side of the ledger before the rest of the assets are even divided. Furthermore, the court often orders the dishonest spouse to pay 100% of the other party's forensic accounting and legal fees as a sanction. Historical trends show that the mere threat of a forensic audit often leads to a sudden discovery of forgotten accounts. In the industry, this is known as the coming clean moment. Once a lawyer files a motion for a forensic expert to be appointed, the other side frequently realizes that the cost of fighting the audit and the risk of being caught far outweigh the benefit of hiding the money. This transitions the case from a detective story into a negotiation. The forensic accountant provides the final spreadsheet, which becomes the roadmap for the settlement agreement. This process of financial unmasking is rigorous and emotionally draining, but it ensures that the division of the marital estate is based on reality rather than deception. But even with a clear financial picture, the case is far from over. The parties must still decide how to divide the most sentimental and complicated asset of all, the family home. In the next part, we are going to explore the real estate and debt traps of the 2026 divorce. How do you divide a house with a 3% interest rate when the current market rates are much higher? What happens to the debt that one spouse hid during the marriage? And why is the concept of transmutation turning separate property into marital property, causing some of the biggest legal upsets in the industry today? We will break down why your premarital savings might not be as protected as you think. The concept of separate property is often the most significant point of friction in the modern American divorce. Many individuals enter a marriage with the nest egg, a retirement account, or perhaps a down payment for a home, under the impression that these funds are permanently shielded by a legal wall. However, in 2026, the legal industry is seeing a massive uptick in cases where those walls have crumbled through a process known as transmutation. Transmutation occurs when separate property is treated in such a way that it loses its individual character and becomes marital property. The most common way this happens is through commingling. In a case study involving a professional named James. Before marrying his spouse Sarah in 2018, James had an individual brokerage account worth $200,000. After they married, James decided to use that account as a rainy day fund for the family. He deposited his year-end bonuses into it, and he occasionally moved money from that account into their joint checking account to pay for home renovations. By 2026, when they filed for divorce, James assumed that original $200,000 was still his. However, the law in most states suggests otherwise. Because James mixed marital funds, his work bonuses, with his separate funds, and used the account for marital purposes, the entire account may now be considered marital property. A divorce lawyer's job in this scenario is to perform a tracing analysis. This is a step-by-step forensic reconstruction of every transaction in that account over the last 8 years. If James cannot prove dollar for dollar that the separate portion remained untouched and distinct, he risks losing half of his premarital wealth. Historical trends show that without meticulous record-keeping, the court often defaults to the simplest path, dividing the commingled asset equally. This brings us to the most significant asset for most American families, the marital residence. In 2026, the real estate market has created a unique and painful legal trap for divorcing couples. During the low-interest rate era of 2020 and 2021, millions of couples locked in mortgages at 3% or lower. Now, as they navigate a divorce in 2026, they are facing a mortgage cliff. The industry is seeing a standoff over the buyout. In a traditional buyout, one spouse keeps the house and pays the other spouse their share of the equity. To do this, the spouse keeping the home usually must refinance the mortgage to remove the other spouse's name and pull out the cash for the equity payment. Let us look at the math of a 2026 real estate trap. Imagine a couple, David and Maria, own a home worth $600,000 with a mortgage balance of $300,000 at 3%. Their total equity is $300,000, meaning Maria needs to pay David $150,000 to keep the house. In 2021, Maria's monthly payment on that $300,000 loan was roughly $1,260. But to buy David out in 2026, she has to refinance $450,000, the original debt plus David's equity, at a current market rate of 7%. Her new monthly payment would jump to nearly $3,000. For many Americans, this 138% increase in the monthly housing cost is a financial impossibility. Divorce lawyers in 2026 are responding to this by utilizing creative, yet risky, legal structures like the deferred sale of the marital residence. In this scenario, the couple continues to co-own the home for a set period, perhaps until the youngest child graduates high school, to preserve the low interest rate. The lawyer must draft an incredibly detailed measure order, or a stipulated agreement, that dictates exactly who pays for the roof repair, who pays the property taxes, and what happens if one spouse wants to move a new partner into the home. These agreements are a minefield of potential litigation, and they represent a shift in the industry from clean breaks to long-term financial entanglements. Furthermore, we must address the Moore-Marsden calculation, a concept used heavily in states like California, but mirrored in various forms across the U.S. This applies when one spouse owned a home before the marriage, but marital funds were used to pay down the mortgage or make improvements during the marriage. Imagine if Maria owned a condo before marrying David. During their 6-year marriage, they used their joint income to pay down $20,000 of the principal and spent $30,000 on a kitchen remodel. Even though Maria's name is the only one on the deed, David has acquired a pro rata interest in the appreciation of that property. The lawyer must hire a real estate appraiser to determine the value of the home at the date of the marriage versus the value at the date of the trial. Step by step, they calculate the percentage of the home's growth that is attributable to the marital contributions. In 2026, with the rapid appreciation of real estate in many U.S. hubs, this community interest in a separate property home can be worth hundreds of thousands of dollars. Then there is the issue of the debt trap. In the United States, we are seeing a historical trend of increasing household debt, and divorce is the moment where that debt is finally adjudicated. Most people assume they are only responsible for the debt they personally signed for. However, in many jurisdictions, any debt incurred during the marriage for a marital purpose is considered a joint liability. Imagine if David secretly ran up $50,000 in credit card debt on business dinners and tech gadgets, that the family never saw. In a 2026 divorce, Maria's lawyer will argue that this is non-marital debt because it didn't benefit the household. David's lawyer will argue the opposite. If the court cannot determine a clear non-marital purpose, Maria might find herself legally obligated to pay $25,000 for debt she didn't even know existed. The industry also deals with negative equity cases, which are becoming more common in 2026 in specific cooling markets. If a couple bought at the peak of the market and now owes more than the home is worth, the divorce lawyer isn't dividing an asset, they are dividing a loss. This leads to high-conflict negotiations over who will be responsible for a short sale, or who will carry the deficiency judgment if the house is foreclosed upon. The legal strategy shifts from, "How much do I get?" to, "How little of this debt can I walk away with?" Step by step, the lawyer must also address transmuted debt. This happens when one spouse uses their separate inheritance to pay off the other spouse's premarital student loans. In 2026, we see many credit for separate property contribution claims. If Maria used the inheritance to pay off $50,000 of David's law school debt, she will likely ask for a reimbursement or a credit during the asset division. However, unless there was a written agreement at the time of the payment, many courts view this as a gift to the marriage, and Maria might never see that money again. As we navigate the complexities of homes, interest rates, and commingled bank accounts, it becomes clear that the paper trail is the only thing standing between a fair settlement and financial ruin. The modern divorce lawyer in 2026 is half attorney, half accountant, and half real estate strategist. But even after the assets are divided and the debts are assigned, there is one final, massive hurdle that can reignite the entire conflict and lead to years of additional litigation. In the next part, we are going into the post-judgment world. What happens when a spouse stops paying alimony or child support 3 months after the divorce is final? How does the contempt of court process actually work in the U.S. legal system? We will look at the power of wage garnishment and license suspension as tools for enforcement. And more importantly, we will explore the modification trap. How a simple job promotion or a new medical diagnosis in 2026 can send both parties back to the courtroom to start the entire legal battle all over again. The divorce decree isn't always the end. Sometimes, it's just the beginning of a new chapter of legal oversight. The moment the judge signs the judgment of divorce, many believe the legal ordeal has reached its definitive conclusion. In the professional divorce lawyer industry, however, this document is often viewed as the beginning of a potentially decades-long regulatory phase. A court order is only as strong as the mechanisms used to enforce it, and in 2026, those mechanisms are more technologically integrated and administratively aggressive than ever before. If a party fails to comply with the specific terms of a decree, whether it involves the payment of alimony, the transfer of a 401k through a qualified domestic relations order, or the adherence to a specific Tuesday night parenting schedule, the legal system shifts from the phase of adjudication to the phase of enforcement. To understand the weight of this, imagine a case study involving a character named Kevin. Kevin was ordered in early 2026 to pay $4,000 a month in combined child support and spousal maintenance to his former spouse, Sarah. For the first 3 months, the payments are consistent. But by July, Kevin, feeling the financial squeeze of maintaining 2 households, decides to unilaterally reduce his payment to $2,000. He believes that because he is still paying something, he is safe. This is a common and costly misconception. In the United States, a court order is not a suggestion, it is a mandate. Sarah's lawyer does not simply send an email asking for the money. Instead, they initiate a step-by-step process known as a motion for contempt, or in some jurisdictions, an order to show cause. The first step in this enforcement machine is the formal filing of the motion, where Sarah's attorney must document every missed or partial payment. In 2026, this is done using automated payment tracking software that highlights the arrears, the total amount of unpaid support. Once the motion is filed, Kevin must be personally served with the papers, notifying him that he is required to appear in court to show cause as to why he should not be held in contempt. This is a high-stakes hearing. In the American legal system, contempt of court is divided into 2 categories: civil and criminal. Civil contempt is coercive. The goal is to force the person to comply with the order. If the judge finds Kevin in civil contempt, they may issue a purge condition. This is a specific amount of money Kevin must pay by a specific date to avoid a penalty. Historical trends in 2026 show that judges are increasingly willing to use the threat of incarceration as a tool for civil contempt. The legal phrase often used is that the contemner holds the keys to their own jail cell. If Kevin pays the purge amount, he stays free. If he does not, he can be taken into custody until the payment is made. Criminal contempt, on the other hand, is punitive. It is designed to punish the person for disrespecting the court's authority, often resulting in a fixed jail sentence or a fine that does not go toward the support arrears but rather to the state. Beyond the courtroom drama of contempt hearings, the 2026 divorce industry relies heavily on administrative enforcement. The most common tool is the income withholding order, or IWO. This is a direct legal command sent to a person's employer, requiring them to deduct support payments directly from the employee's paycheck before the money ever hits their bank account. Step by step, the employer receives the IWO, calculates the allowable deduction based on the Consumer Credit Protection Act, which usually limits garnishment to 50 or 60% of disposable earnings, and sends the funds to a state disbursement unit. The SDU then electronically transfers the money to Sarah. This system is designed to remove the human element and the potential for conflict from the payment process. For the employee, however, having a divorce-related garnishment on their payroll record can create a perceived professional stigma, even if it is legally protected against discrimination. What happens when a person is self-employed or hides their income to avoid an IWO? This is where the industry's most aggressive tools are deployed. In 2026, the intersection of federal and state databases allows for the automatic suspension of licenses. If Kevin's arrears cross a certain threshold, often just $2,500, the state can automatically suspend his driver's license. In a society where driving is often a prerequisite for employment, this creates a desperate financial situation. Furthermore, professional licenses are also at risk. If Kevin were a licensed architect, a nurse, or a real estate agent, the state licensing board could be notified of his non-compliance, potentially leading to the suspension of his ability to practice his profession. Federal law even mandates the denial or revocation of a U.S. passport for anyone with support arrears exceeding $2,500. Imagine if Kevin had a business trip to London scheduled for late 2026. He would find himself flagged at the border or unable to renew his travel documents until his debt to Sarah is paid in full. This brings us to the concept of the modification trap. While orders are final, they are not immutable. The legal standard for changing a support or custody order in the United States is a substantial and material change in circumstances. This is where many individuals find themselves back in the billable hour cycle. Imagine if Mark, another character in our 2026 scenario, was earning $200,000 when his divorce was finalized. 6 months later, his company downsizes, and he is forced to take a job earning $100,000. Mark cannot simply stop paying based on his new salary. He must file a motion for modification. The trap lies in the timing. In almost every U.S. state, support modifications are only retroactive to the date of filing the motion. If Mark loses his job in October but waits until January to hire a lawyer and file the paperwork, he is legally responsible for the higher payment amount for those 3 months, regardless of his actual income. This creates a mountain of undischargeable debt. Historical trends indicate that many people wait too long to seek a modification, hoping their situation will improve, only to find themselves facing a contempt hearing for arrears they can no longer afford to pay. Furthermore, the cost-benefit analysis of a modification is a major part of the 2026 lawyer's strategy. If it costs $5,000 in legal fees to reduce a child support payment by $200 a month, it will take 25 months just to break even. Lawyers must provide an educational overview of these numbers to their clients, often advising against litigation for minor income fluctuations. However, when the change is substantial, such as a permanent disability, a massive promotion, or a child moving from one parent's home to the other, the modification process becomes an essential, albeit expensive, legal necessity. Step by step, a modification case mirrors the original divorce. There is a new round of discovery, a new exchange of financial affidavits, and potentially a new trial if the parties cannot agree. In 2026, we are also seeing the rise of automatic cost of living adjustments, or COLAs, being written into initial decrees. These clauses allow support amounts to increase or decrease based on the Consumer Price Index without the need for a new court hearing, a move by the industry to reduce the burden on an overcrowded court system. As we look at this post-judgment world, it becomes clear that the divorce lawyer is more than just a litigator. They are a long-term risk manager. They must anticipate future changes in income, health, and location to draft orders that are robust enough to last but flexible enough to adapt. But there is a new factor in 2026 that is complicating both the initial divorce and the post-judgment enforcement more than any job loss or move ever could. It is the digital ghost that follows every client. In the next part, we are going to explore the role of social media and digital footprints in the modern divorce. How are private Instagram stories and deleted WhatsApp messages being resurrected as key evidence in 2026? We will look at the rise of digital private investigators and why a single check-in at a luxury resort on Facebook can destroy an alimony defense or a claim of poverty. The way you live your life online is now the most powerful witness in the courtroom, and we are going to show you exactly how the lawyers are using your data against you. In the digital reality of 2026, the courtroom is no longer limited to four walls and a judge's bench. It has expanded to include every server, cloud drive, and social media platform where you have ever left a footprint. The era of hiring a private investigator to sit in a parked car with a long lens camera is rapidly fading. Today, the divorce lawyer industry relies on digital archaeology. Your social media profiles, even those you believe are private, have become the primary source of evidence for everything from hidden income to parental unfitness. The modern lawyer is essentially a data broker, and in 2026, they are using artificial intelligence to sift through thousands of your digital data points to build a narrative that can either secure your financial future or dismantle it entirely. Consider a case study involving a character named Jordan. In early 2026, Jordan is going through a contested divorce with his spouse, Taylor. Jordan is an independent contractor who claims in his sworn financial affidavit that his business has taken a massive downturn, reporting a net monthly income of only $3,000. He argues that he cannot afford to pay the $5,000 a month in alimony that Taylor is requesting. However, Taylor's lawyer utilizes a 2026 digital discovery tool that scours public and semi-public data. They find that while Jordan's official business accounts look bleak, his personal Instagram and TikTok stories tell a different story. The lawyer finds a series of archived stories from a trip to Cabo San Lucas 3 weeks after the divorce was filed. Even though Jordan didn't post any photos of himself spending money, the metadata in the background of a photo showing a sunset reveals a location tag for an ultra-exclusive resort, where the nightly rate is $2,000. Further investigation into Jordan's Venmo history, which was inadvertently left on the public setting, shows a series of payments to luxury car rental services and high-end restaurants. Step by step, the lawyer builds a lifestyle analysis that proves Jordan is living on approximately $15,000 a month. In the 2026 legal system, the judge doesn't need to see a bank statement to find Jordan's testimony non-credible. The digital footprint speaks for itself. Historical trends suggest that when a party is caught in a digital lie, the court's trust is permanently broken, leading to potential outcomes where the judge assumes the worst about every other financial disclosure that party has made. This leads us to the critical concept of the preservation of evidence. The moment a divorce is contemplated, a professional lawyer will send what is known as a litigation hold letter. This is a formal notice to the other party and their counsel, demanding that they do not delete, alter, or hide any electronic data. In 2026, this includes social media posts, text messages, emails, and even data from wearable fitness trackers. If you delete a post or a thread of messages after receiving this letter, you are engaging in spoliation of evidence. The consequences of spoliation in a U.S. courtroom are severe. Judges in 2026 frequently apply the negative inference rule. This means that if you deleted a series of WhatsApp messages, the judge is legally allowed to assume that those messages contained evidence that was harmful to your case. Imagine if Jordan, realizing Taylor's lawyer was closing in, deleted his entire Instagram account. Taylor's lawyer would then file a motion for sanctions. The judge could then instruct the jury or rule themselves that Jordan's deleted account contained proof of the hidden income he was trying to conceal. The industry has evolved to the point where the act of hiding data is often more damaging than the data itself. Furthermore, we must look at the role of metadata and geotagging in 2026 custody disputes. Metadata is the hidden data attached to every digital file: the time a photo was taken, the exact GPS coordinates of the camera, and the device used. In high-conflict custody cases, lawyers are using this to verify or debunk parenting claims. Imagine if Taylor claims that Jordan is consistently late for his 6 p.m. Thursday pickups. Jordan produces a selfie of him and the children at the park, claiming it was taken at 6:05 p.m. Taylor's lawyer, through digital discovery, obtains the original file and looks at the metadata. It reveals the photo was actually taken at 7:15 p.m., and the GPS shows they were at a fast food restaurant, not the park. This level of granular detail makes it nearly impossible for a parent to misrepresent their involvement or their location in 2026. The Internet of Things, or IoT, has introduced an even more invasive layer of evidence. In 2026, your home is essentially a witness. Smart doorbells like Ring, smart refrigerators, and even connected thermostats are being subpoenaed. Imagine if a spouse claims they were home alone and asleep during a night, when they were actually hosting a party that violated a temporary conduct order. The lawyer can subpoena the Nest thermostat data, which shows a sudden spike in home temperature at 11 p.m., indicating several people were in the house. They can subpoena the smart fridge log showing it was open 40 times between midnight and 2 a.m. This is not science fiction. This is the current state of high-end matrimonial litigation in the United States. Another growing trend in the 2026 industry is the use of third-party informants who provide screenshots from private groups. Many people believe that a private Facebook group or a locked Instagram account is a safe space to vent about their spouse or discuss their legal strategy. However, the legal doctrine of the stolen fruit often applies. If a mutual friend or a disgruntled member of that private group takes a screenshot and sends it to your spouse, that evidence is usually admissible in court. There is no expectation of privacy when you share information with a third party. Lawyers are increasingly advising their clients to treat every digital interaction as if it will be read aloud by a judge in a crowded courtroom. Step by step, the industry is also grappling with the rise of deepfakes and AI-generated evidence. In 2026, a lawyer must not only find the evidence but also authenticate it. This has created a new niche for digital forensic experts who specialize in verifying that an incriminating audio recording or a video is genuine. If Taylor produces a recording of Jordan making threats, Jordan's lawyer might hire an expert to analyze the waveform and the background noise to prove it was an AI-generated clone of Jordan's voice. This adds another layer of complexity and significant cost to the litigation, as the battle over the authenticity of a single file can cost tens of thousands of dollars. The financial cost of this digital war is a major driver of the 2026 divorce lawyers' billable hours. Collecting, indexing, and analyzing terabytes of data requires specialized software and hundreds of hours of paralegal and associate time. For the average American, this means that the digital convenience of their daily lives is becoming their greatest legal liability. The industry is responding by offering digital cleaning services, where professionals help clients audit their online presence before a filing. But even these services warn that once something is on the internet, it is never truly gone. As we see, the 2026 divorce is as much about data management as it is about legal statutes. Every like, every check-in, and every deleted message is a potential exhibit in your trial. But what happens when the digital evidence and the financial audits lead to the ultimate showdown? What happens when a case cannot be settled in a conference room and must go before a judge for a final decision? In the next part, we are going into the heart of the machine, the trial and the art of courtroom persuasion. We will look at how lawyers in 2026 prepare their clients for the witness stand and the psychological tactics used during cross-examination. Why is the trial notebook still the most feared object in the room? And what are the secret signals that lawyers use to communicate with their teams during a high-stakes testimony? We are moving from the data to the drama, where one day in court can change the trajectory of your life forever. The transition from the conference room to the courtroom is the most jarring shift in the entire divorce process. In 2026, while approximately 95% of cases in the United States settle before reaching a final adjudication, the 5% that do go to trial represent the pinnacle of legal complexity and financial expenditure. This is where the theory of the law meets the theater of the law. A divorce trial is a bench trial, meaning there is no jury. Your fate is decided by a single individual, a judge who has seen thousands of families and heard every possible excuse. For a lawyer, the trial is a meticulously choreographed performance where every question is designed to lead the judge toward a specific narrative. The foundation of this performance is the trial notebook. In 2026, this is rarely a physical binder but rather a sophisticated, hyperlinked digital ecosystem. Imagine a lawyer named Mr. Sterling representing a client, Christopher, in a high-stakes asset and custody trial in Manhattan. Mr. Sterling's digital notebook contains every piece of evidence organized by witness and by issue. If Christopher's spouse, Emily, takes the stand and claims she never had access to a specific offshore account, Mr. Sterling can, within 3 seconds, pull up a digital exhibit showing Emily's login metadata from 2024. The goal of the trial notebook is to ensure that the lawyer is never surprised, and that every inconsistent statement made by the opposing party is met with a documented contradiction. This is known as impeachment, and in the U.S. legal industry, it is the most effective way to destroy a witness's credibility. Step by step, trial preparation begins weeks or even months before the court date. This involves the grueling process of witness prep. Lawyers will spend hours in mock cross-examinations, throwing aggressive and uncomfortable questions at their own clients to see how they react under pressure. In 2026, some high-end firms even use AI-simulated judges to analyze a client's tone of voice and facial expressions, providing data on what might be perceived as defensive or untruthful. Christopher is coached on the 7-second rule, a pause after every question. This pause serves 2 purposes. First, it gives Christopher time to think and stay calm. Second, and more importantly, it gives Mr. Sterling time to voice an objection before Christopher says something that could be legally damaging. The visual aspect of a 2026 trial is equally calculated. Lawyers often advise their clients on a specific dress code, sometimes referred to as the divorce uniform. The goal is to appear relatable, responsible, and stable. For a high-net-worth individual like Christopher, this means avoiding flashy luxury brands or watches that cost more than a mid-sized sedan. If Christopher is arguing that he cannot afford a specific level of alimony, appearing in a custom-tailored suit with a 6-figure timepiece creates a visual contradiction that no amount of testimony can overcome. Historical trends in the U.S. legal system show that judges are humans susceptible to unconscious bias, and the way a person presents themselves in the well of the courtroom can subtly influence the judge's perception of their character. When the trial actually begins, the process follows a strict procedural rhythm. It starts with opening statements, where each lawyer provides a roadmap of the evidence they intend to present. Then comes the direct examination. This is the part of the trial where Christopher's lawyer asks him open-ended questions like, "Tell the court about your relationship with your children." This is Christopher's time to tell his story in his own words. However, the energy in the room shifts dramatically during cross-examination. This is when Emily's lawyer gets to ask leading questions. Questions that suggest the answer, such as, "Isn't it true that you were in Las Vegas on the night of your daughter's dance recital?" Christopher is restricted to yes or no answers. The strategy here is to corner the witness into admitting facts that support the opposing side's narrative. In 2026, the battle of the experts is often the longest part of the trial. If the case involves the valuation of a complex business or a claim of parental alienation, the judge will hear from competing forensic accountants or psychologists. Imagine 2 PhD-level experts providing completely different valuations for Christopher's tech startup. One expert argues the company is worth $10 million using a discounted cash flow analysis, while the other argues it is worth only $2 million based on recent market volatility. The lawyer's job is to cross-examine the opposing expert, attacking their methodology, their data sources, and even their professional fees to suggest a bias. This is a highly technical and expensive part of the industry, as these experts often charge upwards of $500 an hour for their time in court. Throughout the testimony, lawyers use a series of secret signals to communicate with their team without alerting the judge or the witness. In the 2026 courtroom, this has evolved beyond a simple tap on a pen or a subtle nod. Some legal teams use haptic feedback through smartwatches to signal when to stop a line of questioning, or when a specific digital exhibit is ready to be displayed on the courtroom monitors. There is also a psychological layer to courtroom seating and positioning. A lawyer might sit in a way that blocks the witness's view of their own spouse to reduce intimidation, or they might stand at a specific distance from the witness stand to establish a sense of authority or empathy, depending on the goal of the questioning. The final act of the trial is the closing argument. This is where the lawyer synthesizes days or weeks of testimony into a compelling final plea. In 2026, lawyers don't just speak, they present. They use interactive digital timelines that show the history of the marriage, the flow of money, and the timeline of custody events. They provide the judge with a document called Proposed Findings of Fact and Conclusions of Law. This is essentially a draft of the final order the lawyer wants the judge to sign. If a lawyer has done their job effectively, the judge can take that document, make a few edits, and use it as the basis for the final decree. Potential outcomes of a trial are never certain. Unlike a settlement where both parties have a say in the compromise, a trial hands all the power to the judge. This is the ultimate risk of the divorce industry. A judge might decide to award a spouse more than they ever asked for in settlement, or they might make a ruling that neither party likes. Historical trends indicate that most people walk away from a trial feeling financially and emotionally exhausted, regardless of the legal result. The cost of a full trial in 2026, including legal fees, expert witness fees, and court costs, can easily exceed $100,000 per side for a moderately complex case. But what happens after the judge makes that final decision? What if the judge's ruling is based on a legal error or a total misinterpretation of the evidence? The trial isn't necessarily the end of the legal road. In the final part of our masterclass, we are going to explore the high-stakes world of appeals. We will look at how the appellate division functions and why winning an appeal is one of the most difficult feats in the American legal system. We will also wrap up with the future of the industry, how AI, virtual courtrooms, and new legislative trends are set to transform the way we divorce by 2030. The final verdict is just one piece of a much larger puzzle. When the final verdict is delivered, the immediate reaction for many is either a sense of profound relief or a deep, burning desire to seek a second opinion from a higher authority. In the United States legal industry, this is where the appellate process begins, and it is perhaps the most misunderstood phase of the entire system. An appeal is not a retrial. You do not get to bring in new witnesses, you do not get to show the judge new text messages you found after the trial, and you do not get to re-argue the facts of your life. Instead, an appeal is a cold, technical review of the trial court record to determine if a legal error occurred that was significant enough to change the outcome of the case. To understand this, imagine a case study involving a character named Amanda in 2026. After a 3-day trial, the judge ruled that Amanda's separate property inheritance had been transmuted into marital property because she used a small portion of it to pay for a family vacation. Amanda believes this is a fundamental misapplication of state law. Her lawyer explains that to win an appeal, they must prove the trial judge committed an abuse of discretion or an error of law. In family law, the abuse of discretion standard is an incredibly high bar to clear. It essentially means the judge's decision must be so far outside the realm of reason that it is considered arbitrary or capricious. Historical trends show that appellate courts are extremely hesitant to overturn a trial judge's findings on the facts, because the trial judge was the only one in the room who could see the witnesses' faces and judge their credibility in real time. The step-by-step reality of a 2026 appeal is a slow and expensive journey. First, Amanda's lawyer must file a notice of appeal within a very strict window, typically 30 days from the entry of the final judgment. Missing this deadline by even 1 hour usually results in the permanent loss of the right to appeal. Next, they must order the transcript of the trial. In 2026, while AI-assisted transcription has made this faster, the cost remains significant, often thousands of dollars for a multi-day trial. Then comes the briefing phase. This is where the billable hours skyrocket. An appellate brief is a highly specialized legal document that requires dozens of hours of research into case law and statutes. Amanda's lawyer must find previous cases where higher courts ruled on similar transmutation issues to convince the appellate panel that the trial judge made a reversible error. Potential outcomes of an appeal are threefold. The court can affirm the decision, meaning it stays exactly as it is. They can reverse the decision, meaning the trial judge was wrong. Or they can remand the case, which is the most common outcome of a successful appeal. Remand means the case is sent back to the original trial judge with specific instructions to fix the error. For Amanda, this could mean another year of litigation and another round of legal fees just to get back to where she started, but with a different legal lens applied to her inheritance. Because of this, the decision to appeal is often a purely financial one. If the cost of the appeal exceeds the value of the asset in question, most lawyers will advise against it. As we look toward the future of this industry in 2026 and beyond to 2030, we are seeing a massive structural shift driven by technology and changing social values. The most significant disruption is the rise of online dispute resolution, or ODR. In 2026, many U.S. jurisdictions are moving their low-conflict or uncontested cases to asynchronous digital platforms. Instead of taking a day off work to sit in a courthouse, parties log into a secure portal, upload their financial disclosures, and use AI-guided negotiation tools to reach a settlement. This unbundling of legal services allows individuals to hire a lawyer for a flat fee just to review the final digital agreement, rather than paying a $20,000 retainer for full representation. AI is also transforming the internal mechanics of law firms. By 2026, predictive analytics tools are being used by top-tier firms to forecast potential outcomes with startling accuracy. A lawyer can input the specific facts of a case, the length of the marriage, the income levels, the specific county, and the assigned judge, and the software will provide a statistical breakdown of how that specific judge has ruled on similar issues in the past. This data-driven approach is reducing the amount of guesswork in settlement negotiations. If the data shows a 90% probability that the judge will award 50-50 custody, the higher-earning spouse is much more likely to settle early rather than spend $50,000 fighting for a result that the data suggests is unlikely. Furthermore, we are seeing the emergence of the collaborative law movement as the new gold standard for high-net-worth families who want to avoid the public spectacle of a trial. In this model, both parties and their lawyers sign a contract at the beginning of the case stating that if the case goes to court, both lawyers must resign and the parties must start over with new counsel. This creates a powerful financial incentive for everyone to stay at the negotiating table. In 2026, collaborative cases often include a neutral financial professional and a child specialist from day one, treating the divorce as a family restructuring project rather than a legal battle. The legislative landscape is also evolving. We are seeing a historical trend toward the elimination of permanent alimony in many states, replaced by durational maintenance that is strictly tied to the length of the marriage and the time needed for the recipient to become self-sufficient. There is also a push for standardized child support calculations that include the cost of digital life, subscriptions, high-speed internet, and mobile devices as a recognized basic necessity for children in 2026. These changes are designed to make the law more predictable, but they also require lawyers to stay in a state of constant professional evolution. In summary, the United States divorce lawyer industry is a multi-billion-dollar machine designed to provide order where there is chaos. It is a system built on the billable hour, governed by state-specific statutes, and increasingly monitored by digital footprints. Whether it is the high-stakes drama of a 730 custody evaluation, the forensic hunt for a hidden cryptocurrency wallet, or the technical precision of an appellate brief, every part of the industry is focused on the same goal: the redistribution of assets and the definition of future rights. Understanding this industry is not just about knowing the law. It is about knowing the business of the law and the psychological levers that move the people within it. As we conclude this masterclass on the divorce lawyer industry, we have covered the hook of the initial filing, the math of support, the battle for the children, and the digital war of the modern era. But even with all this knowledge, there is one final proactive tool that is becoming the most important document in the American legal system. It is the only way to opt out of the defaults we have discussed over the last 10 parts. It is the document that more Americans are signing in 2026 than at any other time in history. In our next deep dive series, we are going to pull back the curtain on the world of prenuptial and postnuptial agreements. We will explore how you can write your own rules for divorce before the marriage even begins, and why the 2026 laws on unconscionability mean that even a signed contract might not be as bulletproof as you think. If the divorce industry is the cure for a broken contract, the prenuptial industry is the insurance policy. We will see you in the next masterclass to show you exactly how the wealthiest and most legally savvy individuals are protecting their futures before they ever say I do.